Thank you very much, Alexandre. I will be very short. I would like to thank you very much for your presence here. And I would like also to welcome Anna for her time, and special thanks to Lícia as well, because she will discuss with us, and she will join the conversation, and we will have the opportunity just to look to the Formosa case from other perspectives. So thank you very much to everyone. Thank you very much, Anna. And let's just start.
Hello, good evening or good afternoon, depending on where you are. I feel really honored to be with you somehow this afternoon. And I am, so you, in a sense, you will need to keep me awake because it's 11 p.m. here. And I've been like running because now we are back to, let's say, normal schedule at the European Commission. And it's quite nice, but at the same time, we're not used anymore to run from offices and go to places in person. So in a sense, I'm really upset to not be able to see you around on a like round table, but I will do my best to like guide you with me through this journey. I would like to thank Alexander, Lícia, and Mota to have me tonight, and also all you as participants, researchers, practitioners, and then also an important person. So the chief lawyer of the Formosa plaintiffs is here with us tonight. So I think it would be very nice also whenever if she would like to say something or intervene or just add a comment, this would also make it more more engaging, because we are also learning still on the case, and almost every day we get new insights. So before entering into a presentation, which inevitably has slides, I would like to tell a couple of words on how I arrived here. Of course, not physically, but really through a percourse, through a journey, as I like to call it, which really started, let's say, years ago when I was kind of bored of traditional law in books. And I discovered about this case in Ecuador, so closer to you than to me at the moment, the Chevron versus Aguinda case. And back then I was just a very young lawyer, and I could really work with this I mean, very inspiring person, Pablo Fajardo, who is the lawyer of the Union of Affected People by Chevron Texaco. And this case is a massive example of environmental injustice, because many years have passed and still, despite let's say a positive ruling in Ecuador, the community affected by the oil operation of Chevron Texaco back in the 60s cannot enforce justice because of the corporate strategy and corporate structure of impunity that inevitably dominates the current landscape for environmental law. And I think that was for me a case of like inertia. So nothing could really help these people. And I felt that I really couldn't see them as victims, because they had knowledge, they had passion, they had power. And when I later on discovered that there was a project using drones built by the community, of course with support from external experts, but still the idea was the community itself would learn how to build a drone and operate them to watch over the Amazon permits, to understand whether new violations similar to what Chevron did in the past were occurring. To me, that signified that these people could kind of retake their destiny and do something and use their knowledge to leverage their claims. And in a sense, in the past, what they suffered a lot is also that they didn't have epidemiological and environmental long-lasting data and good records updated of what happened in the all years, decades since Chevron started operating the area. And so kind of three elements came to me as crucial. The fact that the community is there and has knowledge that no one else have. Second, the fact that to demonstrate violation, you really need evidence that are kind of that cover a long time span. And so without this accuracy, you also cannot, you depend on external experts. So the community needs to have their knowledge and their knowledge proved in data if they want to leverage their position. And third, that sometimes technology can help, because when communities reappropriate technologies, so they're not imposed from outside, but they are really made within the community, using the knowledge of the community, then it can be a kind of very powerful, disruptive way of demanding a change, which can come through courts, but can also, like in the Formosa case, but can also pass through like mediation. So for example, pushing outside from the court a settlement to be achieved, or just scaring the actor, the company that you're watching over them. And so this in a way led me to, after my time in South America, to take this academic challenge and start a PhD project on the use of, let's say, after disaster civic monitoring, and how this was impactful for decisions over the governance of the risk. So I give you an example. One of the cases I was following was the Fukushima Daiichi disaster of 2011, and how people there used their knowledge of radiation using this big Geiger, so small Geiger counter for radiation, to counter the scarce information from the government side and to fill informational gaps. And I kind of set the conditions that triggered municipalities, other government actors from other countries, for example, France, also other civil society actors, to use this data and kind of use this data to leverage interventions in a moment where information out there were scarce. But I didn't, let's say in this frame, focused really on the court dimension. So I was looking at policy interventions, but not really at the, let's say, the narrower, but still very dear to me as a lawyer, aspects of using this data to leverage claims in sort of in a tribunal. So now I'm going to let's say, jump to almost now, which is 2 years ago, when the Sensing for Justice project started. And I will show you how all the little dots connect. And so if you agree, I'm going to just introduce to you the context for around 10 minutes. Then I'm going to pause for another 5 minutes or so and see whether there are questions on the frame of the project and on the context where the Formosa case study is inserted. And then we will really dive into the case itself. So as the host, you should be able to see me now with a screen shared. Great. Okay. So first of all, in the presentation, there was something true, but no longer, in the sense that from 1st September, I'm 100% employed by the European Commission. And this part of the project is funded by a Marie Curie Individual Fellowship. But let's say the good news is that the project continues, is just 100% with the European Commission. And so I'm based in northern Italy on Lake Maggiore. So if any of you knows this area, you probably know that it's beautiful. So it's really a great place where to research. And we are in the former Euratom. So it's a former nuclear site, which is also quite interesting because we are researching like environmental disasters in a former nuclear place, but it's also quite fascinating, the whole, let's say, context of research. And something I would like to say is that I think the fact that the European Commission is investing in these projects, even if through an individual fellowship, it's quite remarkable because it shows that even if we are quite behind compared to the US in terms of recognizing civic monitoring, still, especially the European Commission, the Joint Research Center, the environmental protection agencies are, even in Europe, starting to turn their attention to alternative forms of monitoring, which says, I think, something for the shifts that probably governments are making to mirror transitions that are inevitable. So, oops, too far. An important element I would like to introduce you to is that this turn to sensing. What is exactly? And I think you shouldn't think to very complex technology. It's enough to think that if you're biking along a bike path and you see a massive block of dead fishes, what would you do? There are people that would just ignore it. Other would say, why these fishes are all dead in the water? I will call the municipality or call the police or alert an institution. But others may be driven of curiosity or of distrust towards the authorities, would maybe sit there and start observing these dead fishes, understanding why, trying to search for connections, and maybe taking a picture, alerting other citizen, asking an advice from a friend scientist, or taking their knowledge and knowing, for example, that how to or where to bring water to be analyzed. So this turn to sensing means the attitude of normal people, so a lay woman and layman, that decide to use the knowledge and skills they have on get new knowledge to gather data over the environments surrounding them in order to kind of affirm claims. And I think this is quite important because in general, you wouldn't bother if you would trust the institution and know that everything is fine, because each of us has a very busy life and the social contract is based on delegation to appointed institutions. So why should we bother to monitor the environment? And in general, we do that because we feel we are not safe. The Sensing for Justice project is looking at how this turn to sensing is taking numerous dimensions. So first, as a gathering environmental information to claim harms in environmental litigation. So really entering the court domain. Second, given that courts rulings, especially in Italy, but in general, take ages. I mean, not in general. There are countries where it's way faster, but at least they can be also very expensive. So looking at mediation as an avenue where this data can be leveraged and a settlement eventually can be found there. And thirdly, how this idea that each of us has a right to monitor their own environment could even kind of ground a new right, so a right to not only get environmental information, access environmental information, but also contribute to environmental information when the official information out there is scarce. And I would like to mention that here the pictures you see, they don't come from Ecuador or other, like say, traditional oil polluted place. They come from Italy, the southern of Italy, in Basilicata, which is actually a big oil extraction hub and one of our current case study. Luckily, with the pandemic, at least we cannot go to Texas at the moment, but we can go to Basilicata in the south of Italy. And there, for example, people are constantly, they didn't get to court, but with their data, they are alerting public prosecutors to then start a case. So in a sense, we don't need to go that far, at least we that are based in Italy, to see instances where all these three dimensions are really getting through. So, of course, the presentation of tonight is really on citizen gathered data in court, because the Formosa case is a let's say, an iconic example of it. Although, of course, also, I think in a sense, the other two dimensions, especially the right to contribute, comes to the fore. So inspecting citizen data in court, we are looking at which conditions ground the judicial uptake of this kind of evidence. And something I would like to stress is that you will see throughout the discussion of the case that we are not talking of a special type of evidence, at least for the appraisal of the court that judged the Formosa ruling. Because basically evidence is evidence, whatever. So they're not, let's say, adopting a specific citizen science provision. And in fact, also in Europe, there is nothing like a law on admittance of citizen gathered evidence. But for example, looking at jurisprudence of the European Court of Human Rights or the Inter-American Court of Human Rights, we could pinpoint cases where there was nothing mentioned about citizen science, and probably the people didn't even know that they were doing citizen science, but the evidence gathered was really, let's say, participatory between the experts and the community. So we are trying to see whether from a, let's say, stunning cases in the US, if we can also find, let's say, counterpart in our own jurisdiction. And also we are looking at how this big case became also known through media coverage, because in the end, we know extremely now that probably the politics is not made only in traditional fora, but especially on social media, on website, on the internet, and so on. So I mentioned that also the avenue of the jurisdictions of the court endeavor is often not enough, or at least not satisfactory for plaintiffs that are not, for example, as lucky as the case of Formosa, where they could find a very great team up with the lawyers. They had this also free legal aid, and they could really afford to go through a litigation with, I would say, low resources. Of course, mediation has all the conflicts, all the concerns, at least in my perspective, on the fact that it's not a precedent. It's also, it hasn't the guarantees of a court setting, but also in a sense, it stimulates new avenues for dialogue between the institution and the citizen, or the citizen and the company, and eventually could be a way also to alleviate distrust. And we are seeing it, for example, in around Milan, because we are working a lot with like old pollution from industrial sites, and how people are starting monitoring these, and how this monitoring is really becoming a way to leverage their claims vis-a-vis city councils. And they went up to signing a sort of patto, like a contract between the citizen and the city council on which condition would oblige the city council to consider the data from the citizen. So these are creative responses that often kind of flow from a failure. So in a sense, also crises and failures can be constructive, but of course there's need to be a sort of positive attitude by the authorities as well. So a point I would like, so you may know already, I really love comics and graphic novels. I will tell you later that you can also get one from the project. But the idea is that we're not talking about traditional times where science was in a big, like in a small kind of ivory tower. Now science is every day, everywhere. We see with the pandemic. And so in a sense, we're entering this, we enter this post-normal science phase in which science is no longer undebatable, and new legitimized actors emerge that are also claiming their authority and legitimacy, because in the end, they're producing data that can be on a pair with scientific data. So why not considering also these streams? And this is why we think that the right to contribute to environmental information when officially appointed institutions fail to provide information to the citizen is needed for two reasons mainly. One, because it really would create a sort of obligation from the authority side to consider this evidence under certain conditions. But we also think that, especially in cases like Basilicata or Ecuador, where environmental defender can be subjected to even physical menace, so treating themselves, so get really risk for their own life integrity. But let's say on the minimum side, they could get legal conviction, legal claims from the company for, I don't know, trespass, inviting property, or publishing, I don't know, defamation statements. Of course, when this is the case, then the law should intervene. But many times, sadly, especially in the US, this is a strategy through, for example, SLAP, so strategic lawsuits against public participation. So it's a way to silence the protest, not really a way to, I mean, to legally claim your rights. And in this landscape, let's say we're, as being based at the European Commission, you also feel the question, like, should something be adapted? And now the European Commission, for example, is drafting staff working documents, so a sort of internal, well, agreement and a recommendation to member states to use more and more civic monitoring in their enforcement activities. But still, there's no actual legal adaptation, so that there is nothing such a recognition. For example, in the US, there is the the Crowdsourcing and Citizen Science Act that really recognize these forms of monitoring. And in Europe, we don't have it at all. For example, in Ecuador, there is a Ley de Monitoreo Ambiental within a sort of the Ley Amazonica. So within an Amazon law, there is a recognition of civic environmental monitoring. And I think these are already great signs that something is moving. And the case I will introduce to you now in a couple of minutes is really an example of this idea that informational monopolies are no longer possible in a post-normal science context, where citizens can gather the information they need if they team up with good lawyers, if they team up with good scientists. And so in a sense, let's say we're not inventing something, we're just witnessing a reality that is inevitably going on. And I think an important aspect is that we think that the social contract and the idea that there are authorities delegated to enforce environmental law is kind of a paradigm that cannot be challenged. Instead, I think we see increasingly erosion of this paradigm, and the more problems become complex, the more we feel the vacuum in political leadership, and the information becomes fine-grained and entangled, the more also many different actors push the borders of this ivory tower. So in a sense, I really see crisis as productive because they reshuffle the balance of power. And in a sense, I think this Formosa case is a great example to a potential information monopoly. So the information was held by the company, and that was a really black box. And not even the Environmental Protection Agency could enter really effectively in this box. And now the information is really, there are thousands of eyes looking at that. And that is really, I think, the democratic potential of civic monitoring. And there are a number of, let's say, we try to organize our work in a sort of arguments. And for example, we are observing how these civic actors are really legitimizing their position through strategies. And so we published this study really looking at single cases and understanding what were the arguments they were using. So then we are also seeing how these actors use legal bodies that they do have at the moment, like the Aarhus Convention on Access to Information and Participation in Environmental Decisions, adapting it to mirror this idea of a right to contribute. And lastly, we try to kind of also make a parallel to how people were sensing COVID and sensing environmental risk to see whether the pandemic is also creating a sort of new space for legitimizing, let's say, grassroots-driven forms of sensing. And now I would like to, let's say, stop sharing for a few minutes maybe, or a little bit more, and just ask to the audience if you have any question. No question is irrelevant on what presented so far, something that sparked your attention, if you see connection with what you're working on, and let's say whatever would help you to enter the second part. So I see Bella, so I would give the word to Bella.
Hi, Anna.
Just one thing, if you would like to ask question in like French or Spanish or Italian, I can cope with it. With Brazilian, I think I would ask maybe Alexandre or Mota to translate. But I welcome also, let's say, question in whatever language can be translated.
Ok, alors est-ce que je peux parler en français? Ok, merci beaucoup de ta présence ici avec nous. Je voudrais te demander en fait, par rapport au rôle de l'illustration, parce que je fais du droit, mais aussi je suis illustratrice et je suis très, très passionnée par ça. Et l'illustration pour créer justement l'engagement et pour créer justement l'intérêt et pour acquérir et pour que le projet puisse arriver dans des espaces en commun. Dans ton workshop, vous parlez de unusual places, n'est-ce pas? Et je voudrais poser la question par rapport peut-être au prochain projet que vous envisagez avec les illustrations justement, et quel est le feedback, le retour que vous recebez avec ça? Eu vou traduzir, assim, em português. Eu falei da relevância da ilustração, isso me cativa muito, e aí eu perguntei qual é o retorno que eles estão recebendo com o projeto e quais são as próximas ideias para talvez realizar coisas nesse sentido também visualmente. Merci beaucoup, grazie mille.
Thank you to you, and maybe for if there are a few people that don't speak nor English nor Portuguese nor French, I think it's a great question to ask what's how this idea of using drawings and graphic novel to really try to reach unreachable audience, and what are the next steps for this kind of approach. And I would say, I mean, to me, apart from the passion of really using these forms of visuals, is also a way to, for myself and for ourselves, to understand whether we understood well things. Because the more you get simple, the more you realize that what you know really and what you can master. So in the vignettes, the challenge was to really try to sketch with a few lines the meaning, and then the meaning became clearer while sketching. So it's really, in the end, it doesn't have to be a simplification. It's really a process of, like, when you have a strong backbone of scientific content, then you can really get to the kind of illustration, meaningful illustration. And at the end of the presentation, I will share the link to this graphic novel we realized, inspired by a real case in Basilicata, but we didn't use any name. It's a story of oil contamination and impact on humans and animals. And the idea is that this is really becoming a sort of call to action for every community in every part of the world that kind of resonates with this feeling of struggling to access information and then finding a way through. So let's say with the graphic novel, we are having really a great attention, and we are being asked to present in school, presenting, for example, just today, they ask us to come to the pre-COP, so the conference before the COP, the climate big ones meeting in Europe, that's going to be in Glasgow. And I mean, we find this is very agile because it's a tiny booklet, but can be brought everywhere. Like, we just sent to Chile some copies because this friend helped us to translate it into Spanish. So if whoever would like to translate it in Portuguese, I'll be very happy to give you. It's an open access and zero copyright idea. And the next steps, I mean, we are now working a lot with this live drawing idea. So the idea of, like, having an artist drawing live during presentations, during talks. And we are realizing that this is really powerful because it keeps the attention up, but allows also people that are not familiar with law. And so this artist, for example, we're working on, she's not a lawyer, and she's still very able to making like legal concepts down to earth and understandable for people that are not lawyer. And she's getting her knowledge into law, into civic monitoring. So it's really it's an experiment, but I would say it's really a successful experiment so far. And we are not getting, let's say, the risk we could enter is that people would say, you are oversimplifying things, this is not for dumb, and so on. But it's not a problem we are facing. Instead, we are just finding new publics. So, and I encourage you to really keep treasuring your passion if you feel that this is an aspect that you would like to develop, because it's really an addition to the scientific community, and I would say it's not has not been explored as it should so far.
Thank you.
You're welcome. So, I see Andrea.
Yes. Good afternoon. I will try in English. My English, it's more or less, but I will try. Ana, here in Brazil, we have the concept of artificial environment or cultural environmental. When you are talking about of turn sensing, like when we are riding or walking around and seeing things, I keep thinking about in our urban space. See, and here we have this kind of cultural environmental. In the city that I live, called Curitiba, and we have a lot of new buildings come on, and it's I see as a problem, like with our relation that we have with culture with the place, and also the problem of agora eu vou now I need some help here. Professor Alexandre, vamos lá, me ajuda aqui nessa parte, porque além da questão ou alguém, porque além do problema, é porque eu fico nervosa, daí eu não vou conseguir colocar em inglês, faz um tempo que eu não falo, mas além do problema do ambiente, da noção do meio ambiente artificial e cultural, né? Então, as novas construções, como, né, esse espaço que, de certa forma, você pede essa ideia de identificação, né? Então, também aqui em Curitiba, especialmente na nossa Baixa, tem um problema de saúde mesmo, pela questão do acesso ao sol, porque é uma cidade onde tem uma baixa incidência solar, né? E também pela questão dos paredões que vão se construindo, porque tem tem a cidade industrial que foi construído perto. Então, a minha pergunta vai um pouco nesse sentido, de como que essa questão do monitoramento cívico, se ele poderia ser aplicado também no espaço urbano, dentro dessa ideia de um meio ambiente que ultrapassa, né? E se há alguma experiência parecida nos Estados Unidos ou na Europa, desse monitoramento cultural mesmo, e não só cultural, mas também ambiental, desse espaço urbano, né? Que também comporia essa noção um pouco mais ampla do que é meio ambiente. Okay. Acho que eu consegui falar melhor em português aqui.
Vou tentar também. We'll try it. So, just to sum up, she was talking about the urbanization in Curitiba, a city in Brazil, a big city in Brazil, and with so many buildings and the real estate markets and so on, creating big walls and covering the sunlight. And she was asking if we could use this concept of civic monitoring also in urban space, also in not only in environmental conflicts related to forests, but also in urban spaces. And if you know any case about that.
Yes. Thank you, Andrea, for the question and for the translation. I would say the turn to sensing is, in general, sensing, like using our own senses, like smell, sight, is really wherever, because we've been doing that when we were we didn't have a culture, when we were like at the start of history of like people to survive had to sense water, feel whether an animal was coming to attack them. And in a sense, the turn to sensing is just rediscovering our own attitude of being people that are watchful of their surroundings because they need to survive. So the complex evolution of society made us rely more and more on agency, on experts, on technologies, but we still have this, like, think to the smell of something burning is, or feeling an earthquake is something you really are like, you don't learn to do it, you just do it. And of course, in the case we're going to discuss, people were like observing and collecting plastic from water. In other cases, people smell. there are cases where people use technology, but in general, it's like we are sensors even without using any technology. And for that, we can be especially exposed to things, to sense in cities, definitely. And I would give you a couple of examples. Imagine that like the city is really the juncture of many pollutants. In a sense, in places like a bay or a lake, you have more to preserve because it's less destroyed. But still, in a city, I mean, my hometown is Rome, and there, the example of fishes is because it happened to me, I think 2 months ago, that you bike through the bike lane on the Tiber River, and you see that fishes in the water, but not one, really dozens. And so I think in the city, you have kind of almost even more an obligation to sense, and you can sense many things. Like you can sense pollution, but you could also sense violence, for example, in the city. So the idea of being a watchful citizen, a watchful person, can apply in many places. And I can give you these 2 examples from Europe. One is really, it's called like Damous, and it's a big initiative to track and also regulate odor pollution. And interestingly, people perceive odor way more than what a sensor would do. And so often there is a mismatch between what the agency reports and what the people feel. And the distress that a pervasive odor can cause can also may not have health effects, but can have like generate, let's say, momentaneous headache or nausea. So there are also health impacts, of course, of odor. So this is really, and Damous is written like D. I will write it here, and then if you Google it, you will find a lot. And the second one is in Belgium, and it's about like air monitoring, so air monitoring in the city. And they became so massive with this initiative that basically the Green Party that supported this initiative like won the election for the critical mass that formed around this initiative. And they even partnered, let's say, with Greenpeace and filed a successful court case supporting like the violation of air quality standards for Central Europe. So, and it all came into cities. So it started from cities. I will also add the link here. So like I would say in your city, you can especially be sensor. Think to biodiversity, like how are birds feeling all this massive construction, but also, for example, reporting health distress of traffic. So effects of a new railroad, a new street close to houses, for example. So let's say, I would say the long story short, you can be a great sensor also in cities. So that would be my short answer here. So any other question?
Yes, I have my own question, but first of all, I'd like to thank you, Marta, very much to give us this opportunity to have you here with us. And thank you very much for your very precious presentation. It's very interesting. And I think from a litigation strategy, it's very rich. I'd like to ask you something in this sense, that how could you use in terms of litigation strategy the citizen gathering evidence? Here in Europe, it's not very applied. I mean, you cannot use it like in the United States. But I was thinking if it could be possible to use it in terms of, for example, amicus curiae, or maybe in the context of maybe popularity, actions popularity. And how do you see if you could transpose it to Europe in terms of litigation strategy. I don't know if you are developing these ideas in your research, or.
Yeah, I think thank you, Lícia. That's a great question. And I mean, basically the structure of amicus curiae, amici curiae, is basically the avenue we are now looking at in Europe, where this is way more common than, for example, class actions or really grassroots driven claims, like in the US is more popular. So in a sense, we would need a sort of gatekeeper organization. So an association like Greenpeace or Friends of the Earth would be and sort of intermediary and support also the development of a civic monitoring and take this into a sort of brief report that is then addressed to the court. To us, this is a bit a problem when it kind of enters, also it shapes the data collection. There is an agenda of the association or the organization. You can imagine like that Greenpeace as an overarching agenda that can go beyond or even conflict with that of the narrow communities that is exposed to the problem. So we would welcome instances like the one of the Formosa case I'm going to illustrate, because in a sense this group, the water keepers, were really, let's say, formed around the issue. So they are, of course, their struggle and their battle go beyond the narrow case, but there is quite an overlap between the agenda of the water keeper and really the needs of the fishermen in the area. So we would welcome, let's say, maybe local association, smaller scale association that would take on board these claims and support them eventually with an amicus curiae. But we hope that in Europe also cases like this can occur, and what we would see as promising, let's say, it's really using the Aarhus Convention framework, which would differ a lot from the US, for example, because the Aarhus frameworks really ground an obligation for governments to listen to data from the citizen when this is contributing to fill environmental data gaps. And this could be let's say, a rich justification vis-a-vis a court if the failure from the government or the Environmental Protection Agency to publish the data is recognized. So we need pilot cases. So I'm trying to push a group of lawyers to really start going in that direction. And interestingly enough, we are now starting from climate litigation, which is a field that is opening more in Europe on the, let's say, also on the wave of the Dutch key case, Urgenda, of Juliana in the US. So also in Rome, for example, it has been filed this Giudizio Universale, which is a big court case against the Italian government for not meeting the threshold for climate mitigation. And the plaintiffs are normal people, let's say, and they are considering the plaintiffs to start turning also to evidence from climate migrants that came to Italy. And we think that this would be a winning and powerful form of civic science, because we would ask these people to really document scientifically the impact of climate change on their daily life. So I have no data to share because it's nothing real at the moment. But I have to say that there is movement towards this direction. So I would say in my life, I will see big developments in this sense. And I think in the next 5 years, there will be something like a case also in Europe. So
I hope so too.
Great. Any other question? Okay, so I think so far we're ready to dive into the core of the case. So I'm just going to share my screen again. If you can see it, perfect. I guess you can see it. So first of all, something I would like to say about this case is that we discovered the case in 2019, but the case, in a sense, the data collection started way earlier. And from 2016 to 2019, let's say, sensing citizen, the people that we consider as those that monitored and patrolled their environment, were active to kind of demonstrate also a sort of the span of the contamination and not just, let's say, an instance. The case allowed us to really frame what citizen collected evidence come to be when they face the court. So how the court reads this evidence. We looked at what is really original of this case, but also what can we learn from this case for other similar cases. And of course, talking about patterns is difficult because I will show you why this case is very, very unique. But we think that there could be implication also for the European jurisdiction. So first of all, the Formosa case is still stunning for us for how impactful it was. And for example, in the last months, I've discovered the creation of this global archive, which is an archive of Formosa legacy, this big Taiwanese company, multinational, effects on various communities around the world. And after publishing this study, we've been contacted by lawyers working in France, lawyers working in Indonesia, in many different places, and they still, of course, in Taiwan, and they had kind of common stories. And I think these stories converged in this archive, where now we are really happy that one of our drawing became part also of the banner of the archive. And I mean, I think this idea of like also joining the forces, also communication-wise, is a very, I mean, I would invite you to also go and check this archive, because also in terms of perspective is quite original. The case is also led by a champion, by this person, a fisherwoman, a very very proud person, Diane Wilson, who you can see in this in this banner, and she really motivated people, and that confirmed us the theory of the champion, that many times this case is moved because one person really battles and goes on and kind of with this charismatic attitude push the community to join, gather, and struggle. And something we realized as well is that also the team of lawyer and the plaintiff could create a very nice relationship. And I think on that I would also maybe invite Amy to comment a little bit more later on if she would like to share the experience. But also, like, the lawyers were very motivated and very dedicated, and didn't take it just as a job, but really as a struggle, a battle to be fight. So in a sense, I think this is amazing because it doesn't always happen, at least in our view. So we can question, analyzing the case, under which conditions can civic monitoring be accepted in court as legal evidence? And we framed what can be called the judicial uptake of citizen sensing, and I decided to call it like this because in my PhD project I was looking at the policy uptake of citizen sensing, and I think this is on a let's say on another level. It's really it's not like trying to steer an environmental protection agency to implement a decision. It's really to, I mean, you're dialoguing with a power that is also controlling the state. And sometimes, especially in environmental matters, courts are being more open-minded, the governments are really being the place where the change starts to occur, like the Urgenda case in the Netherlands. So we also enter into more fine-grained questions. So exactly which types of evidence count as citizen science, because citizen science is a quite vague term. How can this term then be put in context? How the judge classify this evidence, and against which standards the admissibility of this evidence was assessed. Because of course, one of the things they always say about citizen science is that it doesn't fulfill the scientific standards of quality. And lastly, yes.
Can I just interrupt you one second? Just because I think you have to move the screens, the little screens to the right or to the left. No. I don't know if it's with me, but I'm seeing a black shadow, like black square.
Maybe
you have to, because it's, you have to move the.
Let me see if this is getting better.
Not better.
Okay, thanks.
Thank you. Perfect.
Sorry for letting me know. No, it's important also because now there is text in the slide, so it's important that you can also properly read them. Right, and exactly the last question was really which weight did this evidence played in the overarching ruling, considering that there were a combination of evidence, so also agency fundings, company audits, testimony by expert witnesses. So of course, there was not only a citizen science evidence, but it was a combination thereof. And let's say, to the experience that we heard from the plaintiff, from the lawyer, is that the civic evidence played a crucial role. So our methodology was really to combine traditional text analysis of the case. We tried to stick as much as possible to the ruling and then move from the text of the ruling to reading communication over the case, like social media interaction. But we really also wanted to understand what the experience of the plaintiffs and of the lawyers were. And so we tried to reach them. And I have to say, it was a really nice experience because we could also, question some of our assumptions. Just reading the case, you don't get, of course, the full picture.
This kind of responds to some of the questions y'all are asking. One of the very practical things I would say about citizen evidence is you need to have a methodology of collecting, because people these days, one of the wonderful things are phones. Phones, you can get free GPS on your phones, and people should just be taking pictures and using that GPS, and it'll and put the time and date on it, because people will, because a pellet or a dead fish looks like a dead fish anywhere. Okay, and once you put your GPS identification on it, and once you put the time and date, you don't have to remember, it's there. You took it and you can see it. It's a very practical thing. And the other thing I would say as a practical matter is it's important to think through what it is you're trying to take evidence of and see how agencies like to look at things and how experts like to think about things, so that you capture information that's useful. So for instance, Diane Wilson would go out after a rainfall event and look in certain particular places. And then after the water had flushed through, she would look again, and there would be no plastics. So we could show different periods of time. Again, we had GPS and date and time. We didn't at the beginning. That's why I'm telling you this, because you could spend a whole bunch of time taking pictures and not be able to use them because you didn't categorize them well. And it's just at the very beginning of it, it's just an important thing device to think about, is how how you want to present it and how you want to record it. So sorry, I'm sure, there we go. I just gave him a little practical tip.
So
I think this is really wonderful. And I mean, maybe as we stopped a bit sharing, I would like to personally ask a question to Amy to really share with us how you got to be involved in the case, in the sense you knew about what they were doing also before becoming the lawyer of the case, or it was something like I mean, you found the case and then you got so into it.
So in the United States, there's an organization, a federally funded organization called Legal Aid, and it pays for lawyers for low-income people. And in Texas, there's an organization called Texas Rio Grande Legal Aid, which has a history of I started doing it in the 80s, of doing environmental justice litigation. And so I'm a private lawyer and I consult for Legal Aid. But so they funded experts, and I have worked for them for years. I've done this citizen evidence stuff on all kinds of other issues, teaching people words to use for odors and all kinds of things, diaries, journaling. But we were contacted because somebody from Legal Aid had that geographical region of Texas to work in, and he was in the community, and Diane Wilson had been following this company for many years, and the company had a permit coming up. They had a permit that allowed them to discharge water into Lavaca Bay, and Diane Wilson wanted to comment on it. That was 2013. And so I was hired to work on the comments. We negotiated a bunch of things on the permit, but one of our comments was that they were discharging plastic pellets into Lavaca Bay. And one of the lovely things is they said, if we did that, that would be illegal. No, we're not doing that. And the agency said, no, you don't need a permit condition because that would be illegal. So years later, after they get their permit, we go out and start looking for them. And when they've already said it's not supposed to happen. But so that's how I got involved, is I was a consulting attorney for Legal Aid, and I was called in. And then as the case got bigger, we put together a team. Like there are two other private attorneys, one who does environmental law, one of them who's one of my best friends from college, who is a trial lawyer. And I brought him, and he has a great staff person that we had. So we had a big team. We called ourselves, here's a little insider story, we called ourselves Team Sunshine because we were happy and we liked each other. And the other team, they were kind of, not happy. So that I had Team Sunshine t-shirts made for our team and the kids of our team, our experts, and they had little kids. And so anyway, but that's how, and we were happier. You're right. We all got along. We were going to have a big old barbecue, and then the darn pandemic hit. So c'est la vie, huh? It'll happen someday.
That's amazing, also because there is kind of the assumption that environmental matters are boring and like you are or you never get success. And I think that's a bit the story we heard about failed cases. And of course, it's wise to see also this side, but I think it's great to also be happy while you struggle. And I think to be constructive, for me, it's a citizen scientist, a constructive attitude, a person that doesn't stay with their hands like this and crying on themselves. It's really like, I'm trying to do something, and if it fails, it fails, but I still did something. So I really like it. So great. I would ask Alexander if I could again be the host, so I will be able to share again the screen. But I think we really entered into the flesh of the case, so I will be, let's say, try to be brief in the next step, so we can open again the question stage. Perfect. Okay, so we now are in this kind of let's say technical slides. We're a bit let's say for the lawyers around the table, like it's a matter of a civil law proceeding. was still at the local case in Texas before the U.S. District Court for the Southern District of Texas. And maybe I'm just making again my little screen so you can see it better. Sorry, it went beyond. The Victoria Division and the plaintiffs were an environmental association. So this San Antonio-based Swearing Waterkeeper, which was part of is part of a larger nonprofit. So again, this sort of also gatekeeper in a sense, in the sense that there is an association that is beyond a single citizen, but there were also civic actors like local residents, fisherwomen, fishermen, even former workers of the company. The defendant is this corporation, which is a multinational company owned by like a Taiwanese corporation, and this company, so it's also of course a symbol of what it means to be like a big multinational, in the sense that as is owned by this very multi-billionaire person. And the type of advocacy, I stress again, is really a dedicated champion, because Diane is a person that's kind of drives debates, drives people, and so that's also a pivotal element in our frame. So the type of evidence submitted, it's quite interesting because there's a combination indeed. So photos, videos, containers with sample of plastics collected by the citizen on site in critical conditions, as Amy was saying, but also compared with agency findings, Formosa own reporting, auditing, and they managed all this evidence combined to demonstrate repeated violation of the US Clean Water Act through non-compliance with their permit for a persistent discharge of floating solids, so what we called as plastic pellets, but also little debris, so plastic powder. And not only like the actual violation, but also, of course, not reporting, and thus breaching also the right of every inhabitant to know what was being dumped in the water. So these all made to this final ruling, which was in 2019 in June, and then in November 2019, the consent decree was approved, which was negotiated by the parties and endorsed settlements between the parties and the companies, which is likely being implemented. So not only a winning ruling, but also a ruling that is implemented, which compared to cases like the Ecuadorian case seems a big deal. And then I will also ask Amy if she would like to inform us on the really lively period they are going through now, because they're really watching over compliance of Formosa with the terms of the ruling and with the promises. And also, in a sense, this is making other companies kind of watchful, because they are aware that courts now are ready to punish them if they don't comply with their permits. So it's interesting, the methodology, because it was a really like long-lasting sampling with a very systemic approach. So it's really not an episodic or extremely, let's say, experiential. So a person that decided to tell about the experience of plastic pellet. No, it was really a team, and a chain of custody was implemented, where the plastic that was collected in the water was passed to a person who would record it, and then pass it to the lawyers team that could then register them. So it seems a structure that reminds a lot what scientists would do to sample a problem. And as I was mentioning, these charges were spanning from 2016 to 2019. And probably for the type of evidence, because it was so evident, but also the methodology was strong. So there was no contestation by the court nor the company of this type of collected evidence. And this also seems important. So the decision is a huge victory. It's a monetary relief amounting to $50 million in mitigation payments. And what we were discussing at the beginning is that really this is an injection of energy, not only really for like kind of remediation, but really boosting the traditional fishery activities, preservation of local tradition, of local balances, and so also oversighting the allocation of this payment. It's very important for the community because it's again being the participants, be the protagonist of this debate. And very simply trying to disentangle what was really key elements in the case. So one element that we went through a lot to also get to understand the difference from, for example, cases like the Damous, the one of like odor pollution. In a sense, it was very tangible and not involving sophisticated monitoring. So it was really about gathering plastic compounds in water and kind of systematizing them, and was not about monitoring water or assessing odors. So this simple type of evidence was combined with a sort of simple qualitative legal standard. So the permit that Formosa violated said that the permit would have been violated when in water would have been discharged more than trace amount of plastic. So more than trace amount doesn't require a quantitative limit. So demonstrating that is beyond a certain threshold is really about seeing whether is what you see in the water is more than trace. And if you see it, is already more than trace. And in fact, what the plaintiffs could see was definitely more than trace, because they were plastic that could be collected in little bags. So you can imagine that was definitely not trace. So another important point is really the triangulation of evidence. So the idea that various evidence could strengthen each other and become, let's say, one demonstration. And then it's also quite important that there was a sort of dedicated champion, so a person that could really kind of channel all the efforts, all the data collection. And lastly, really this rigorous data collection. So the idea that citizen science, to be considered, as Amy was saying, really need to be rigorous. Otherwise, it would lose on the first attempt. So I wouldn't enter here too much, given that we don't have really an US audience into the discussion on the standards of evidence, but we could enter into that later on in the discussion. There was an image here, but I don't see it anymore, so maybe it's just too heavy for my internet tonight. I want to stress the fact that the case is stunning, and so inevitably as limitation for the lesson to be extended to, for example, European or South American countries, because of course all these elements together are not very easy to be found. But I think already the fact that there is a Formosa archive is pushing to other cases like this to kind of start moving. And for example, already the Charleston case, which is another case that for various people in the debate mentioned to me as a possible other interesting case, shows that really there is a move, there is a trend towards that. And also I think it's quite interesting that the regulators are being warned, and now they're like enforcing permits probably more than before, because they know that also the citizens on the other side are ready to sue. So the let's say we would like to welcome you to also try to get into the reading of this study. It's open access. It's also, I mean, there will be also a picture here, but I will send the slide afterwards anyway. I want to conclude also to exactly welcome you to enter more the flesh of the project through the story of a civic sentinel, which maybe could, let's say, motivate you towards, I don't know, new avenues where the civic monitoring in your own context can bring you to. And to end and to kind of give some prompts for discussion, I would like to ask you what broader implication you think this case could have for enforcing environmental justice really from the ground. So from where it is needed, not big declaration, but really narrow interventions. And then also, if you're an expert of evidence law, do you think this case is stunning? Because in the end, the judge didn't label the evidence as citizen science, just assessed the evidence for what they were. They were proofs of plastic more than trace amount in the water, and that was a violation. So it didn't enter into, is it citizen science, is it not? Is there any legal recognition of citizen science? So it just applied the federal rule of evidence, so the standard legal framework for evidence law. And I would say this is reassuring for other communities, because you know that you won't be discriminated for the fact that you have citizen science evidence or less or not. But on the other side, it also creates uncertainty, and it depends a lot on how the court would perceive this evidence, but also, of course, on new citizen scientists, there is the burden to make the evidence as credible, as accurate as any type of evidence. So I think in the end, regulating a specific type of evidence as citizen science would not necessarily be appropriate and let's say a benefit for the communities in the end. And lastly, of course, I would be very curious to hear from you whether you have parallelism, you have other cases you think we should look at. Of course, especially in Brazil, I would be quite curious about. And then I just leave you the page of the project and my Twitter account. And I'm now, I think, on midnight, we can just open the floor for further discussion. But maybe before really opening to questions, I would like to just give the word to Amy, if she could share some words on the current status of the consent decree implementation and of this, let's say, system for monitoring plastic in water that you've been implementing.
Sure. The settlement, the money from the settlement, just so you know, went to a trust fund that has certain places where the money has to go. It's all in the consent decree, which might be interesting. Also, the money goes to, is awarded. There are a lot of studies going on. There's some great things being done with the money that I could tell you about, but the other things to know about, the consent decree included a requirement that engineers be hired to re-engineer the plant so that plastics would not be discharged. And that our team gets to monitor and comment on that, and that the case does not end until the engineering has been completed and there are no more plastics being discharged for 6 months. Our team is paid by Formosa now. That's part of the agreement. All the work we do, all our experts are paid by Formosa at standard private attorney rates and private expert rates. That's a nice thing to have in a settlement. A second part is that there's a monitor whose job is to go regularly to the creek and regularly at this other device, which I'll tell you about, to determine if there have been new discharges. We've had one fight over what a discharge is, which has gone to an appellate court since the case settled. And the monitor has been going out there, and I'll go back to the monitor. The third is that there is a cleanup crew, and the cleanup crew's job is to clean up these multi-miles of a creek and to clean up the bay, the shore of the bay, which is going to involve digging up dirt, removing trees. I mean, the plastics are deep into the soils. But one of the other parts of the settlement is that our engineer, Dr. Isa Jose Sanchez, was going to design a way to test Formosa's wastewater effluent. This is their treated wastewater that then they discharge continuously 24/7 into this bay. And it's just gone online maybe in June, and it is a huge facility. We just did a filing about it in court. You're welcome to look at it and see the photos of it, but it detects whether there are plastics in the wastewater. And this facility, she's applied for a patent. This facility should be used on all plastics companies' discharges if there's any possibility of plastics in their effluent, because it also detects tiny powders and tiny flakes as well as pellets. And since it's gone into, part of the agreement was that they would continue to pay fines that go into this trust whenever plastics were detected being discharged. And this is called the wastewater sampling mechanism. And it is, I think we're now up to $450,000 more that has been paid in $20,000 fines for additional discharges just from June. So I could tell you specifically, but I don't remember off the top of my head, but it's a lot. Every time but once that they have looked into this net that she's designed to capture pellets, there are pellets in it. And it takes just a 3% sample of their discharge. So, you know, it's a tiny amount, but it's a tiny amount of a big discharge. So we are going to be working on this case for years. You know, we're in year 2, and the epidemic made it a little harder, but we've continued to work on it. In fact, we're negotiating. We're negotiating at this moment about how the wastewater sampling mechanism will work. But it's detecting plastics, sadly, but it continues to detect plastics. So I really do hope that if any of y'all have plastic companies you're dealing with, that you'll look at the wastewater sampling mechanism as a new technology it's expensive, but the plastics companies make a lot of money.
And I remember, I am not sure if you or Diane told me that you're also considering patenting it. So really making it like a sort of standard for other companies and eventually the regulators to use it. Do you think there is an attention by the regulators and by the company to, I mean, purchase these or implement these preventively and not really to find new violations?
I don't know. You know, it's just the patent is pending. Other companies don't know about it, but now there is a reporter from this Plastics News, which is an industry organization to industry journalistic journal, that he will probably report on it. But I don't know that industry wants to do this. You know, it's going to have to be government to tell industry to do it. Texas is a pretty industry friendly place. They have other plastic companies, and it'll be interesting to see. Texas has a pending rule to regulate plastics. In fact, they changed their rule to go from trace amounts to 0, which is what we got in our settlement, to go to 0 discharge of plastics. And but industry went after them, and I don't actually know where the rule is. It's still pending before the agency, but they proposed 0. So I don't know. All I can hope is that once the information is out there, that people in other places will look at it and see it as a very useful technology.